CBI Director Ranjit Sinha, whose role was under scanner of a Supreme Court appointed panel on whether his decision had led to scuttling of probe, now finds himself in a soup. This after the panel has found that charges levelled against him were in fact correct. Ashmit Kumar, who has been tracking this case from a very long time, joins in now. Ashmit, give us a quick background of the case, and it looks like Sinha has finally run out of rope.
Well, it would appear to be the case, especially if the ML Sharma committee report is anything to go by. I'll get to that in just a bit. But first, a little brief backgrounder on this case. What we understand is that there were allegations made against Ranjit Sinha that his decisions with respect to closing a few investigations were in fact tantamount to scuttling of the coal scam investigations, primarily because there was a register which surfaced which detailed various coal scam accused visiting Ranjit Sinha at his residence post-working hours. Dozens of occasions. That is what inspired a great deal of suspicion in terms of the conduct of the former CBI director. Now, subsequent to this question being raised in this apex court, the Supreme Court had appointed a panel headed by none other than the former special CBI director, ML Sharma. Now, that ML Sharma committee, that ML Sharma panel has submitted its findings, and the findings here are critical. It is, in a manner, an indictment of the role of the suspicious role of the former CBI director. Now, it's important to clarify that these findings of the panel are prima facie in nature, but nonetheless, the panel observes it does make disparaging comments with respect to the conduct of the former CBI director. It also goes to the extent of saying that there is a certain degree of influence that can be seen with respect to these meetings having been conducted and the subsequent decisions that were taken by the then CBI director. So some sharp comments. But what's interesting here is that the government, represented by none other than the Attorney General, sprang to his defense. The Attorney General clarified that all the calls taken by the CBI director were in fact vetted by the CVC. Here, the AG also argued that at this point, not sufficient evidence is available to certify the authenticity of the register itself, the diary which details these visitors to his residence. And finally, the AG argues that there is just not enough to proceed with on a criminal prosecution. So that's the stance that the government has taken. But meanwhile, the petitioners in this case are unequivocal when they seek at least an FIR. They're seeking an SIT ideally. They say that there's enough evidence available to suggest the complicity. So the Supreme Court for now has reserved its judgment. More clarity on that is awaited.
Very, very